Still going on a lot of immigration interviews, mostly green cards in the last 2 weeks. This week I went with a married couple to their adjustment interview. So the wife actually was abroad at the time that I got hired, and her spouse decided to sponsor her for a fiance visa, K1. Um, that took maybe about a year and a half for the K1 visa to be approved and then issued by the embassy in her home country. And then for a K1 visa, the requirement is that once the foreign fiance enters the US on the K1, the couple have to get married in the US within 90 days. As long as that condition is met, um, then the foreign fiance can just apply directly for adjustment of status. There's no I-130 petition that's needed to be filed by the US citizen spouse, um, which is nice. And the other interesting thing about adjusting status as a fiance is that at the adjustment stage, you technically don't even have to provide proof of the marriage being real. So that's what happened this week at my client's interview. I think it was, in all my 26 years of practice, it was the shortest interview I ever had. Showed up to immigration. Um, I think the interview was scheduled for around 11:20, something like that. I got there at 11:20, got through security right away. There were no lines. We checked in, and then within 10 minutes, we were called by the immigration officer. Also very rare in New York City to be called pretty that quickly, in my experience. The wait time to be called, at least where I am here in New York and New Jersey, is, you could be waiting minimum, I would say, hour and a half, sometimes up to 3 hours or longer. So to be called within 10 minutes, that's like rarely happens. Um, and then the interview itself, it went super fast. I mean, we were done in 10 minutes. The officer just was really quick with the questions. Only asked to see my client's birth certificates, passports. I had prepped my client and I told them to bring all of this evidence that they were in a real marriage, living together, et cetera, et cetera. Even brought their photo album. And after about 10 minutes, the officer said, okay, well, everything looks fine. I don't need anything. So just to make sure, I asked the officer, well, do you want to see any joint documents, any bona fides of the marriage? And she said, no, your client entered on the K1, and as long as they married within 90 days of entry, then that's all that's required for the adjustment to be approved, assuming that there are no other red flags. Like, obviously, for example, if a client has an arrest record, a conviction record, or any other issue, then obviously that wouldn't be the case. But assuming no other eligibility issues, um, all that's needed to adjust based on a K1 is that the marriage did in fact take place in the US within 90 days of entry. So my clients were kind of shocked that the interview ended so quickly, and they were like waiting to be asked to submit all these joint documents that we had prepared, um, and ultimately did not need. But, I mean, I take that as a very nice surprise, not to have to be grilled at the interview about like, how did you meet, or, the typical questions that officers ask at marriage interviews. They're always trying to suss out whether or not it's a real marriage. So if you were thinking about, fiance visa as an option, that's, I guess, like some of the benefits to the K1 is that the petitioner doesn't have to file an I-130 family petition. And, the evidence of the bona fide to the marriage can be waived by the officer, like in this case. There's, I mean, every now and then clients consult with me about this question of which route should we pursue? If we have the K1 to adjustment as an option. Or alternatively, if the foreign fiance already has another type of visa, like a visitor visa, they often ask me what's better, should my partner enter the US first on the visitor visa and then we apply for the green card? I mean, theoretically, both should work, but if you are considering option number two, which is coming to the US on a visitor visa, you want to be careful about timing and also about possible questions that the Customs and Border Protection Officer might ask you at the airport. So intent is very important. If you were entering the US on a visitor visa, there's a possibility the officer at the airport could ask you, why are you here? What's the purpose of your visit? And if your ultimate plan is you want to get married to a citizen, and then apply for the green card, obviously, if you're ever questioned, don't ever lie, just be honest. And if that's your true intent, then the officer might find that that is counter to the visitor visa. Someone who has a B1, B2 is supposed to show that they don't have any intent to immigrate anytime soon. So it's a little contradictory to enter on a visitor visa if you plan on applying for a green card pretty soon after you enter. So that's just something to think about. And, I've had clients decide one way or the other, basically depending on their timing. When are they looking to get married? Would they prefer to just go through the K1 process because the foreign partner, a lot of the time, there could be reasons why they need to wrap up things in their home country. So they're not in a particular rush to come to the US and apply for green card right away. And then I've had clients want the other option, they are in more, would like to get the green card process rolling faster. So if you're not sure, you might want to talk it out with an immigration lawyer to kind of weigh the pros and cons. What are the timeframes in terms, like, what are the different timeframes for both options? What kind of issues do you want to be on the lookout for, such as possibly being questioned by CBP at the airport? But yeah, I mean, that case was approved the next day, so I'm really happy for my clients. Um, I also have a few more interviews coming up in the next few weeks. All marriage-based green card applications. In my experience, the USCIS offices here in New York and New Jersey are still kind of, functioning the way they were before the new administration. I haven't seen that huge of a change. Hopefully that will continue. Other things that are on my plate right now. Did a consultation this week with a client who has DACA right now. And her question is if there is a way to obtain a green card if an employer is interested in sponsoring them. So, there might be a way, but just in general, for someone to be sponsored for a green card through an employer sponsorship, whether that's through a perm labor cert or EB1A, or even Schedule A, which is an EB2 category. One of the main requirements to be eligible to adjust status is that the beneficiary has to be in a valid non-immigrant status at the time that they file their adjustment application. So the issue here is that DACA technically is not a status. It is not non-immigrant status and it's not immigrant status either. It's something in between. So it technically is a something called deferred action, which means that the government knows that somebody doesn't have valid status, but they are not going to actively prosecute that person, i.e., put them into deportation proceedings. So a lot of people have DACA right now. Um, and, you know, the whole question of whether or not they can eventually receive a green card, it depends on, who is the sponsor. Is it a family petitioner or is it an employer petitioner? And the rules for eligibility to adjust status are pretty different when it comes to the petitioner being a family member versus an employer. So just to give you an example, I've had clients who had DACA, but let's say when they first came to the United States as children, they entered with a valid visa, such as a visitor visa. Let's say they applied for DACA when it would became available under President Obama by executive order, and they've been renewing their DACA for years. They meet someone, fall in love with a US citizen. They then apply for a green card. So in that fact pattern, the client would be eligible to adjust status because when they initially entered, they were admitted and inspected because they entered on their own visa, right? So for a client of mine who just had their adjustment interview about 2 months ago, that was pretty much the fact pattern. Their adjustment application was approved. But that's not the same outcome wouldn't happen if a client who's on DACA now did not initially enter with their own visa. If they were not inspected or admitted and paroled, then technically they're not eligible to adjust status. Let's say they entered without inspection, meaning they came to the US through the border. They were not seen or detected by an immigration officer. So technically, they did not enter with permission. And on top of that, they don't really have proof of how they entered. So someone under that circumstance, even if they later got DACA, that's not enough for them to qualify for adjustment of status. What some clients do in some cases is if they have DACA, they will then apply for advanced parole, which is permission to travel outside the US and return. So DACA recipients are eligible to apply for advanced parole. And if you are able to obtain advanced parole, you travel outside the US and then you re-enter on that. A lot of the time that will make you then eligible to adjust status because that re-entry on the advanced parole kind of wipes away the previous entry. So for this consultation, that's what we are looking into is if she were to apply for advanced parole, leave the US, re-enter on that, would she then be eligible to adjust status based on an employment position? So, I think there might be a way forward with that case. Let's see. Another consultation I did this week, it involves a family-based green card application where unfortunately the family based adjustment was denied by immigration. And the family wanted to know what other options do they have. So what they did was they filed an I-290B motion to reopen the denial of the adjustment, which has been pending for about 2 years. And one of the things they were exploring is, can we sue the government for this delay by filing a mandamus? So that was the initial request for the consultation. But once I started talking to the family more and found out more details about why immigration denied the adjustment, my advice was that you don't want to sue the government if you have a shaky application. Because for something like mandamus, it's just to get a federal court to order the government to do something that they have been delaying, right? So you can't make a government agency approve a case by filing mandamus. Um, Especially if the thing that you have applied for, it's not a clear-cut case where you should be approved or have to be approved. You may not want to use mandamus because it could really backfire on you. Um, After talking to the family members, my conclusion was that, when immigration denied the adjustment, they had a basis to do that. There was something in the application that was defective. And, you know, if immigration's denial has a leg to stand on, like the reason that they gave for denying it makes sense, is logical, and can be, based on law, then why go through the appeal? That was one of the questions I asked. And they didn't seem to really know why, it was just something their attorney recommended. Um, so we went through the whole possibility of mandamus. I didn't recommend that. Instead, I recommended that they simply just refile the adjustment, this time um, with documents that would remedy the error that immigration pointed out. Refiling is in almost every case faster and more straightforward than filing an I-290B. Why? Because immigration doesn't like to reverse decisions made by previous officers. That would be like the agency admitting that they messed up. Um, if it was a clear mistake or clearly erroneous denial, yes, there's a possibility that immigration could then say, you are right, we shouldn't have denied this. But more often than not, they don't like to disturb decisions that they already made. Um, and there's nothing in the law that says that you can only apply for one petition or application once, and if that was denied, then you can't ever file another application again. So in my mind, it makes a lot more sense to just simply refile the adjustment, remove the error that was made in the past, and most of the time you'll get a decision much faster than pursuing the I-290B. Um, the other thing to think about is that for any applicants for adjustment of status, if you have since fallen out of status, that's something else to look out for, because immigration, it's very enforcement heavy these days. So whereas in the past, let's say immigration denied a naturalization or denied an adjustment application, sometimes they would just leave it at that and not do anything further. But I would say in this day, don't be surprised if immigration will take a further step beyond denial, which means they could be looking at possibly referring someone into deportation proceedings, right? Because if someone entered on a visa, then applied for adjustment of status, that adjustment is then denied. And then guess what? By now, the applicant's visa has expired. They're not in valid status anymore. Guess what? They are technically deportable. So just be on the lookout. That's why you want to be a lot more careful with whatever you are applying to with immigration. Just kind of make sure that you want to bulletproof the applications, try to avoid any errors to the extent possible. And you just want to like thoroughly weigh the risks, the benefits obviously, but also the risks of applying. What if immigration denies? What could happen next? And then if you're not sure, then really consult with a lawyer. What is immigration doing now for naturalizations that they're denying, for adjustments that they're denying? Some clients who are going through this process alone may not know that, you know, getting something denied by immigration might not be the last thing that will happen to you. Um, there's also a higher risk of detention at various stages in the process. So I'm hearing from my other immigration lawyer colleagues of having their clients picked up by ICE at biometrics appointment, asylum interviews, even some adjustment interviews, even some naturalization interviews. Of course, not meant to scare everybody, but it's not that immigration is doing this across the board. That's definitely not the case. I don't mean to like, please don't be panicked about it. But I think it really depends on like the particular facts of the case. If there's anything kind of unusual about the client's immigration history, if there's any interaction with law enforcement, if there has been a previous deportation case, if there was any incidents of immigration fraud, those are really big red flags right now. Um, and I would say if any of these are true, then you have to always be thinking, anytime immigration schedules you for an appointment, just, just be aware, right? That USCIS is contacting, the USCIS is in contact with ICE, right? In some cities, they're in the same building, different floors, right? So all they need to do is just pick up the phone and say, I have someone here, they're scheduled for an adjustment interview. They have whatever, an outstanding deportation order. And then lo and behold, ICE is there waiting for you at your interview. So when in doubt, consult with an immigration lawyer, who has experience dealing with these issues, who has experience handling deportation cases, cases involving mixed questions of immigration and criminal law or asylum or whatever your case is. Just kind of like you want to talk to somebody who is up to date and familiar with the local ICE office or local USCIS office or local immigration court. Because that's the other thing is that depending on the jurisdiction, some offices handle issues differently. So like one office might be have a higher chance of detaining clients than other offices. Geographical, geographic differences are a thing with immigration. Because even though immigration is federal law, the field offices don't all act the same, right? Some offices are better than others are more strict. So that's something else to take into consideration as well.